On August 14th, Rebel Creamery filed for bankruptcy. 2 days earlier, it had filed an appeal against a $23.8 million judgment. And the whole thing started with a carton of ice cream. At least, that's what the headlines make it sound like. The filings say something stranger. Here's the short version. A federal judge in New York ruled that Rebel's pints copied the look of a competitor's pints. Not the name, not the logo, the look. Cardboard, pastel colour, black cursive lettering. And then he did something courts almost never do in public. He opened up a private company's books and worked out how much of its profit came from the outside of the tub. His answer was 2/3. Before we go further, this is live. The judgment is under appeal, the bankruptcy is open. Everything here is what a court found as of August 2026. And it could change. So how does a cardboard tub become a $23 million problem? To answer that, we have to go back 10 years, to a decision that had nothing to do with lawyers. My team just told me that 70% of our regular viewers still haven't subscribed. We're trying to reach 5,000 subscribers in the next 60 days. So if you enjoy these videos, please subscribe. It's free and it would really help us reach that goal. 2016. Van Leeuwen is a New York ice cream company with a problem every food brand has. Walk down a supermarket freezer aisle and look at what you're up against. Chocolate splashes, waffle cones mid-air, caramel pouring in slow motion, gold foil, exclamation marks. 40 tubs all screaming at once through a sheet of fogged glass. So Van Leeuwen hired Pentagram, one of the biggest design firms in the world, and did the opposite. No photo of the ice cream, no splash, just a pastel cardboard pint and a name in black cursive. In a case full of noise, they went quiet. And understand what a risk that was. Every convention in that freezer exists for a reason. The photo of the ice cream tells you what's inside. The caramel tells you it's indulgent. Strip all of that out, and a shopper glancing past has almost nothing to go on. It could read as premium. It could just as easily read as empty, or cheap, or like something that wandered in from the yogurt section. What they were betting on was recognition, not information. And per the court's order, the numbers moved. From 2014 to 2016, Van Leeuwen was growing about 36% a year. From 2017 to 2018, after the redesign, it was growing 92. Growth nearly tripled. Same ice cream. But a look that works that well is a look worth having. And in September 2017, about a year after that redesign, a company started in Midway, Utah. To understand why this matters, put yourself in the freezer aisle as a business rather than a shopper. You've made a keto ice cream. Good product. Now you need someone to buy it. You have no shop, no salesperson, no ad budget, and about 1.5 seconds of a stranger's attention as they walk past. What do you actually have? A rectangle of cardboard. That's it. In grocery, the packaging isn't advertising wrapped around the product. It is the sales team. It's the only thing doing the selling at the moment the decision gets made. And the scale here is lopsided. US ice cream is roughly a $19.5 billion market. Keto ice cream, globally, is around 527 million. Those are private research estimates, so treat them as rough. A small category inside a huge one. which means you're not fighting for the freezer. You're fighting for a few inches inside a freezer that's already full. And that space isn't given away. A buyer at a national chain hands over shelf space on the expectation your product sells fast enough to justify the inches. Miss that and you're out at the next review. No second launch, no slow build. You get a window, measured in months, to prove the product moves. Which means the carton isn't just doing the selling, it's the thing keeping you in the store at all. Rebel's first pints appeared in a Los Angeles health food store in August 2018. Within about 18 months, they were in Publix, Kroger, Walmart, H-E-B, Safeway, and 7-Eleven. That is an extraordinarily fast run into national grocery for a company nobody had heard of 2 years earlier. Van Leeuwen noticed in late 2018, and then did nothing for 2.5 years. You'd assume that's a legal strategy. It wasn't. Then Van Leeuwen testified they hesitated because the company didn't have much capital and had never filed a lawsuit before. Having a right and being able to afford to use it are completely different things. They filed in April 2021, 4-day trial in October 2024, ruling in July 2026. 7 years, roughly, from noticing the problem to holding a judgment. 21 months from the end of the trial to the decision landing. And in the meantime, Rebel kept selling. Which brings us to the arithmetic, because this is the part that has no real equivalent anywhere else in business. The law here works in 2 stages. Van Leeuwen had to show Rebel's revenue on the accused products. Then the burden flips, and Rebel had to prove its costs and prove how much of its profit came from something other than the packaging. Think about what that second half asks you to do. You have to prove what was going on in your own customers' heads. Rebel's argument was reasonable. People buy keto ice cream because it's keto. The carton is incidental. Van Leeuwen's answer was a survey. It reported a net confusion rate of 34.3%, roughly a third of shoppers linking the 2 brands on the basis of the packaging. That's the move. It stops being an argument about taste and becomes a measurement. The court went through revenue, expenses, and equitable considerations and put Rebel's profit on the accused pints at about $35.5 million. Then it cut 33% for the keto demand that was genuinely Rebel's own, which leaves $23,785,000, assigned to the way the carton looked. So how was a judge confident enough to draw that line? A folder of old files. Van Leeuwen came to trial with the whole history of its design. The original brief to Pentagram, all 7 concepts that were presented, the ones that got rejected, the revision rounds, and the Pentagram partner who ran the project in the witness box. Sketches, mock-ups, dated emails, dead ends. According to the record, what came back the other way for Rebel's packaging was 1 finished Illustrator file. No sketches, no rejected concepts, no drafts. And think about what a folder of rejected work actually proves. Not that the design is good, that it was arrived at. 7 concepts means 6 roads not taken. Dated revisions means somebody argued about a typeface on a Tuesday. Every dead end is a timestamp. A finished file proves the destination. Only the drafts prove the journey. The court's finding was direct. Judge Committee wrote that the evidence at trial left no doubt that Rebel infringed and diluted Van Leeuwen's trade dress, and did so intentionally. That's a court's conclusion, reached under evidentiary standards at trial. It's being challenged on appeal, and it may not survive. There's one more detail in the order. Before Rebel's first retail launch, a buyer at Wegmans is recorded as having warned Austin Archibald that the cartons looked like Van Leeuwen's. Per the ruling, nothing changed. And if you design anything for a living, This is the part worth keeping. The side that saved its rejected drafts won. Documentation isn't admin. In a fight like this, it's the evidence. But there's a reason this judgment came out the size it did, and it's not the one you'd expect. Back in 2024, after problems in discovery, an earlier order limited Van Leeuwen to equitable remedies. In plain terms, they lost the ability to claim compensation for their own losses. All they had left was disgorgement, a claim on the other side's profits. At the time, that was a defeat. And it's worth being clear on the difference, because the two questions are almost opposites. Compensation asks, what did you lose? You'd have to prove which shoppers would have bought your pint, in which stores, in which months. Nearly impossible. Disgorgement asks a different question entirely. Not what you lost, what they made. Now think about what each path was actually worth. Van Leeuwen's own lost sales would have been hard to prove, and almost certainly modest. Rebel's profits on the accused pints were $35.5 million. The setback is the reason the number is enormous. And a number that size does something specific to a company. On August 14th, Rebel filed Chapter 11 in Utah. Read the schedules instead of the headlines. Assets, $13.78 million. Cash, $5.22. Receivables, $2.59. Inventory, $5.65. Liabilities, $23.85 million. And the Van Leeuwen claim inside that? $23.785. Listed as disputed under appeal. That one disputed claim is 99.7% of the fixed unsecured liabilities. Take it out, and there's barely any other fixed unsecured debt on the page. This isn't a business that slowly ran out of money and then got sued. The judgment came first. The balance sheet followed it. Which brings us back to those 2 days in August. August 12th, Rebel files a notice of appeal. August 14th, Chapter 11. And here's what the second filing does, mechanically. Under Section 362 of the Bankruptcy Code, filing triggers an automatic stay. Every lawsuit, every collection effort against the company stops instantly. Nobody has to grant it. So the position today is a $23.8 million judgment, an appeal arguing it's wrong, and a stay, meaning nothing gets collected while that argument runs. Chapter 11 is a restructuring process, not a shutdown. Rebel products are still on shelves. The company is still trading, which is roughly the opposite of what most of the coverage implied. We're not going to guess at anyone's intentions here. That's for the appeal court, not us. But structurally, two instruments existed. One challenges whether the number is right. The other pauses what happens if it is. Both were used inside 48 hours. So, was this really about a carton? Yes. And that's the part worth sitting with. Because in any product sold off a shelf, the design isn't decoration wrapped around the asset. It's the thing standing in for a salesperson at the exact second someone decides. A court looked at that and priced it. 2/3 of $35.5 million. And that number travels well beyond ice cream. Every brand sold on a shelf is running the same bet, that a stranger recognizes something before they've read a word. Cereal, skincare, coffee, beer. Anything where the decision happens in a couple of seconds in front of a wall of options. For most companies, that's a marketing line item, a cost. This ruling says it can be an asset, with a number attached, and a claim if somebody takes it. The wrapper was worth more than the ice cream. One last time, because it matters. The judgment is on appeal, the bankruptcy is open, and both could change this picture completely. This is accurate as of August 2026, but whatever the appeal decides about the number, it won't change what the number was measuring. Somebody spent money on cardboard, and a federal court called it an asset.